Let us start with Secretarial Practice, Chapter 5, Articles of Association. Company incorporate under Companies Act obtain legal identity separate from its member. As company is an artificial person created by law, company laws have special importance in the life of company. Memorandum determines the object, share capital, liability of members, address of registered office, etc. of the company, but the implementation of objectives of Memorandum of Association and the rules and regulation about the management of the company, rights and duties of member, etc. are determined by Articles of Association. Let us see to the meaning and explanation of Articles of Association. Articles means articles of association of a company as originally framed or as altered from time to time or applied in pursuance of any previous company law or the Companies Act 2013. Article means the set of rules governing the internal administration of a company. These rules cannot be contrary to the provision of Memorandum of Association. It implies that the provisions of Memorandum of Association of a company are binding of Articles of Association. It is presumed that every person dealing with a company is aware of the provisions of Article of Association. The first importance of Article of Association is useful in daily administration. The policy and rules of internal management of the company are stated in the Article of Association. On the basis of these policies and rules, the daily administration of company take place. Second is important for secretary. Article of Association is very important for secretary. The important rules prescribed in the Article of Association regarding the interpretation of various routine words, rights and responsibilities of shareholders, distribution of shares, rules regarding installments, forfeitures and transfer of shares, rules regarding office administration and functioning, provisions of meeting, accounting rules, appointment of directors, auditors, clarification of their authority, duties and responsibility, etc., help the secretary in office administration and functioning of a company. Third is useful for the shareholders. Article of Association is a supplementary document to the Memorandum of Association. It contains clarification of the rights and liabilities of the shareholders, rules regarding general meeting of shareholders, voting procedure of shareholders, guideline regarding dividend to the shareholders, etc. are mentioned in Article of Association. Fourth is useful for determining various relations. Article of Association determines the relation between the company and its members. It also regulates the mutual relationship of the members of a company and internal relationship of the members. Fifth is useful to ascertain the nature of the company. By the study of article, the type of company can be known, that is, whether it is public company or private company. If the company limits the number of its members, puts restriction on the transfer of its shares and prohibits the invitation to public for subscribing to shares, it suggests the company is a private company. Articles of Association describes the details of how the company should manage its different activities. It keeps control on internal affairs of the company. Articles of Association is also provide important information to the secretary for the administration of the company. The legal provisions pertaining to the Articles of Association. Now, some important provision of Article of Association are narrated in various sections of the Companies Act 2013, which are as follow. First is signature of Articles of Association. Who are the signatories? So, every person giving signature in the Memorandum of Association has to put a signature in the Article of Association. Second is details of the signatories. Third is signature in front of witness. Fourth is specimen of the Articles of Association. Fifth is follow of provisions. That is, whichever provision of Article of Association is, that is to be followed. Company cannot escape from its liabilities towards the member. Sixth is provision against law. Seventh is provision for private company. There must be minimum 2 and maximum 200 members in the company. There must be restriction on the share transfer. The company must not invite the public to purchase its own shares. Then eighth is presumption of law. The law must presume that every person related to the company is aware about the provision of articles of association. Ninth is right to get copy of articles of association. 10th is amendment in articles of association. Company may amend in its article of association by passing special resolution. 11th is affidavit of promoters, that is, article of association must contain the affidavit of the promoters containing the statement to the effect that they are not found guilty for any offense relating to the establishment, incorporation or administration of the company. Content of articles of association. The article of association includes the rules for the daily management of the company. The promoters of the company can independently frame its own rules, but these rules should not be against the provision of Companies Act. In addition to this, the details contained in it should not be against any existing laws of India. Generally, the article of association contains the following particulars like primary agreements, then information related to share, about the shares of private company, rules relating to meeting, rights and duties of board of directors, rules for the dividend, and the number of shares and the face price, then the share installments related to rules, then the rules related to transfer of shares, lien of the company about the value of unpaid shares, rules about transmission and forfeiture of shares, and so on. In the article of association, it is necessary to include the information mentioned in the table which is applicable to the company out of table of schedule of the 30. Introduction of table F, G, H, I and J of schedule I of the Companies Act 2013. First, let us learn about table F. Article of association of a company limited by shares. Article of association is a document showing internal administration of a company. So at primary level, board of directors have freedom to decide policy and rules for internal administration of their company. But there are various tables in schedule 1 of Companies Act for different types of companies. The companies have to prepare their article of association considering the detail mentioned in the table. So table of schedule 1 of the Company Act 2013 have mentioned the detail to be presented in article of association of different companies, and accordingly they have to continue with it. First in the table it is mentioned about table F, company limited by shares. So you can see the points. So each and every company will have different rules. So accordingly we have to follow the rules.